Good afternoon. We've called today's hearing to examine H.R. 3356, the Access Act, which Mr. Lundgren of California introduced to make a minor but very important change to the Americans with Disabilities Act, the ADA. The Access Act is a common-sense proposal to require plaintiffs to provide defendants with written notice and an opportunity to correct an alleged ADA violation voluntarily before they may file a lawsuit and force a business owner to incur legal costs. This legislation, which applies to cases involving physical barriers to entry in public accommodations, would both improve public access for disabled individuals and eliminate thousands of predatory lawsuits. When the ADA was signed into law by President George H.W. Bush in 1990, the goal was to provide the disabled with equal access to public facilities. And in large part, the ADA has worked. Unfortunately, enterprising plaintiffs and their lawyers have abused the law by filing tens of thousands of ADA lawsuits aimed at churning out billable hours and extracting money from small businesses rather than improving access for the disabled as the ADA intended. These predatory lawsuits are possible for two chief reasons. First, 100% compliance with the ADA is very difficult to achieve. Even through good faith efforts such as hiring an ADA compliance expert, a business can still find itself subject to a lawsuit for the most minor and unintentional of infractions. According to one ADA compliance specialist, quote, "I rarely, if ever, see instances where there isn't an access violation somewhere. I can find something wrong anywhere," close quote. This makes a compliance challenge even for those with the very best of intentions. Second, unlike Title II of the Civil Rights Act, the ADA does not currently require any notice before a lawsuit can be filed. This has led to thousands of lawsuits being filed for issues of relatively minor noncompliance, such as a sign being the wrong color or having the wrong wording. Abuse of the ADA has been noted by federal judges in numerous cases throughout the country, who have referred to the proliferation of ADA lawsuits as a, quote, cottage industry, unquote. These judges have recognized that the explosion of private ADA litigation is primarily driven by the ADA's attorney's fees provision. One federal court explained that the ability to profit from ADA litigation has led some law firms to send disabled individuals to as many businesses as possible in order to have them aggressively seek out all violations of the ADA, close quote. Then, rather than notifying the businesses of the violations and attempting to remedy them, lawsuits are preemptively filed, since settlement prior to filing a lawsuit does not entitle plaintiffs' counsel to attorney's fees under the ADA. As one federal judge observed, the result is that, quote, "the means for enforcing the ADA, attorney's fees, have become more important and desirable than the end, accessibility for disabled individuals," close quote. But the ADA was enacted to protect disabled individuals, not to support a litigation mill for entrepreneurial plaintiffs' attorneys hunting for ADA violations just to file lawsuits. The Access Act would help eliminate predatory ADA lawsuits and increase compliance with the ADA by giving businesses the opportunity to fix ADA violations instead of dragging them into litigation. Lawsuits would be reserved for those instances in which offenders are truly unwilling to make appropriate changes. This would also allow legitimate claims to move through the system, the legal system, sooner and faster. Moreover, requiring notification before filing an ADA lawsuit will benefit our economy. Many small businesses have been forced to close because of accessibility lawsuits, and others have unnecessarily spent thousands of dollars litigating claims. Small businesses are critical to America's economic recovery and should not be burdened by unnecessary or predatory litigation. The Access Act should protect the interests of the disabled and of America's small businesses and ensure that ADA violations can be remedied without the need to file a lawsuit if possible. The Access Act preserves the rights of the disabled and fixes the ADA so that professional plaintiffs are not able to exploit this landmark civil rights law for their own private gain rather than for the benefit of the disabled. And with that, I would now yield to the ranking member of the subcommittee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. We've been here before. 12 years ago, movie star and California business owner Clint Eastwood testified in support of legislation that would require pre-suit notification before a claim could be filed under Title III of the ADA. And we've had legislation on this introduced in every Congress since then, including this one. Though Mr. Eastwood testified passionately about the need for pre-suit notification to prevent business owners like himself from being victimized by unscrupulous lawyers, the plaintiff and lawyer in his case actually had notified him of the alleged violations at his resort before filing suit. Proponents of pre-suit notification ignore the fact that, as in Mr. Eastwood's case, a demand letter does not always work. Not every business owner will gladly make changes to increase accessibility, nor is it clear why a letter should be required where a violation is obvious or where 22 years after enactment of the ADA, a public accommodation has taken absolutely no steps to bring itself into compliance with the law. Pre-suit notification is a virtual get-out-of-jail-free card for every public accommodation in America. By requiring a person with a disability to notify a public accommodation before bringing legal action to enforce the law, bills like H.R. 3356 remove the only incentive for voluntary compliance with the ADA, namely the risk of being sued and having to fix the problem and pay reasonable attorney's fees. Title III of the ADA does not allow private parties to sue for money damages. Only in order to remedy the ADA violation and reasonable attorney's fees are possible, and then only if the plaintiff is a prevailing party, that is to say that the defendant is found to have violated the law. By removing the risk of litigation, H.R. 3356 would send a clear and devastating message to every public accommodation in America that there is no need to comply voluntarily with the ADA. Instead, wait and see if you ever get a demand letter. 22 years after passage of the ADA, many businesses remain inaccessible to persons with disabilities. Yet instead of talking about how to improve compliance, here we are again considering a bill that further excuses noncompliance. Proponents claim that pre-suit notification is needed to stop unscrupulous lawyers who have made a so-called cottage industry out of filing lawsuits in order to force businesses into quick cash settlements and who have no intention of increasing access for persons with disabilities. But let's be clear about one thing. There simply is nothing unethical or inappropriate about suing a business that is violating the law. The filing of a single or even multiple suits alleging violations of the ADA or state disability laws says nothing about the underlying merits of that or those suits or the intent of the parties involved. Moreover, there's absolutely no reason that the mere filing of a lawsuit should result in years of costly litigation. A defendant who is sued under Title III of the ADA in response to a summons by agreeing to remedy the problem, as we are assured would be the case if only pre-suit notification were required, faces only the cost of the repair itself and reasonable attorney's fees. Courts decide every day whether a fee request is reasonable and will not approve an award that is disproportionate to the actual work done. While some might prefer that attorneys who enforce the law were to get nothing for their work, thus eventually forcing them out of business entirely and reducing the possibility that those who violate the law will ever be brought to justice, Congress decided to allow reasonable attorney's fees with the understanding that doing so is necessary to enable private lawyers to help enforce the ADA. Whereas may sometimes be the case, the lawyer actually does engage in affirmative misconduct, for example, by providing misleading information, by making factual or legal arguments in bad faith, or by unreasonably and vexatiously prolonging a matter, courts have the tools they need to sanction this misconduct and often do so. Courts in California and Florida, for example, have sanctioned lawyers who have brought ADA and state law claims where the underlying allegations were not sufficiently supported or where the lawyers misled the defendants. The courts have required these lawyers to pre-file any future suits with the courts, or in other cases have denied attorneys' fees and damages available under some states' laws. It is an unfortunate reality that some lawyers may act inappropriately, at least some of the time, but this is not limited to lawyers who represent plaintiffs. One of our witnesses here today, Mr. Peters, whose practice consists of defending against ADA and state disability lawsuits, was found to have, quote, acted intentionally in bad faith for an improper purpose and with an intent to harass the plaintiffs, unquote, in one case. Explaining why sanctions against him were warranted, the district court explained that Mr. Peters, quote, unreasonably and vexatiously multiplied the litigation, which resulted in excess costs, expenses, and attorney's fees to the other litigants, unquote, and that, quote, this is the essence of frivolous and bad faith litigation, close quote. I'd like to submit the district court's ruling in that matter, along with the Ninth Circuit's order affirming sanctions against Mr. Peters, for the record. Thank you. Thank you. This makes clear that the courts can and do handle complaints about attorney misconduct. And the notion that the mere filing of lawsuits alleging noncompliance with the ADA is itself an indicator of bad faith or frivolous litigation should be rejected. Indeed, as courts that have imposed sanctions against vexatious litigants have been careful to recognize, given the fact of widespread noncompliance with the ADA, lawsuits themselves are not an evil to be avoided, but the only way of enforcing the ADA and thus of achieving its goals. As the Ninth Circuit said in Molsky versus Evergreen Dynasty, quote, for the ADA to yield its promise of equal access for the disabled, it may indeed be necessary and desirable for committed individuals to bring serial litigation, advancing the time when public accommodations will be compliant with the ADA, close quote. To the extent that continued noncompliance with the ADA is leaving businesses vulnerable to litigation, the appropriate solution is to beef up technical assistance or otherwise determine what more is needed to ensure affirmative voluntary compliance. We should not enact legislation like H.R. 3356, which seeks to excuse every public accommodation, whether large or small, and even when knowingly and deliberately violating the law, from taking any steps to comply with the law until and unless it receives a specific enough demand letter. With that, I look forward to hearing from our witnesses and yield back the balance of my time.
Thank you, Mr. Nadler. And without objection, other members' opening statements will be made part of the record. Our first witness is Representative Dan Lundgren of California. Mr. Lundgren represents California's 3rd Congressional District. He was first elected to Congress in 1978. From 1991 to 1999, Mr. Lundgren served as Attorney General of California. In 2005, he returned to Congress and is currently the chairman of the Committee on House Administration and is a member of the Judiciary and Homeland Security Committees. Mr. Lundgren, your written statement will be entered into the record in its entirety, and I would now recognize Representative Lundgren for 5 minutes to make an opening statement.
Thank you very much, Mr. Chairman. Thank you, Mr. Ranking Member, and other members of the subcommittee. Since my statement will be entered into the record, let me just say a couple of things. One is that my staff and I have spoken with dozens of small business owners in California, restaurants and other small business enterprises. And the number one fear that they express to me is the fear of abusive ADA lawsuits. They tell me they want as many customers as possible to come to their store. It's not in their business interest to put up barriers of entry for people to come in. But in fact, the practice in California, and especially in my district, where you've had thousands of lawsuits that have been filed, in most cases without any specificity, and the claim that is being made or the grievance that's being presented without specificity gives no opportunity for the owner-operator to be able to respond in a meaningful way and thereby do what we really want this law to do, actually result in access. My bill does nothing to change the underlying ADA. Rather, it requires that the grievant put in writing with sufficient specificity that the owner-operator understands reasonably, a reasonable person could understand, what is in fact in violation of the ADA. It then gives that individual an opportunity to respond within a specific period of time in writing, again with specificity as to how they are going to handle it. And then the third part is that there would be a period of time which the owner-operator can actually make those physical changes. Now, if the owner-operator does not do these things, it seems to me the grievant is in a remarkably enhanced position as they go to court, because if I'm a federal judge, the fact that the owner-operator basically did not take this seriously and there is any basis whatsoever for finding that there is a violation of the ADA, that puts the defendant, I think, in a very, very poor position. In fact, that would be the best mechanism by which you could achieve access sooner rather than later. I'm aware of a sandwich shop that was defended in an ADA lawsuit in which the litigant never visited the shop but used Google Maps to determine that the disability or handicap signage was missing. The plaintiff in this case sued for trauma and embarrassment as a consequence of being able to access a business that the plaintiff never visited. In another case that's come to my attention recently, a locksmith owner in my district who himself has a disability closed his shop in mid-April 2012 to undergo surgery. When he came back a month later to reopen, he learned that a generally stated ADA lawsuit had been filed against his business. His attorney advised him that at his age, it would probably take a number of years for them to resolve it. The cost would be excessive, and he never opened his doors again. The business owner called this extortion. Other tenants in the building may be told that they have to move as well. That's not what the ADA was intended to do. Now, the ranking member referred to this as a Republican proposal. There is bipartisan concern about the ADA. In April 2012, in a letter, U.S. Senator Dianne Feinstein wrote to California Senate President pro tempore Darrell Steinberg and stated this: "Today, we are still witnessing an alarming rate of demand letters that are being sent to small business owners demanding settlements in the range of $5,000 to $8,000. The payment of this settlement amount, combined with the cost of hiring a lawyer to respond to the demand letter, can easily add up to more than $15,000 in costs for a small business owner. As you know, these unforeseen costs can be devastating to the mom and pop stores that are struggling to remain in business." It is not, therefore, a partisan issue. There's an effort going on the state level in California to try and respond to this in some enlightened way. So I hope this is not viewed in a partisan way. I hope that members will understand that there is a need to tweak this law, to make it more effective, to reach what I think we all on a bipartisan basis want, and that is access that has been established, not long litigation. The abuse falls disproportionately on small businesses. And in my state, it falls disproportionately on minority-owned businesses, which happen to be, in most cases, the ones that have less capital than others. Oftentimes, it falls on those operators whose first language is not English. And frankly, they have difficulty responding to a generalized letter of complaint. And really the demand that they get is pay up or you will suffer. And that's what we're trying to get away from. Again, we do not in any way change the underlying proposition of ADA. We attempt to try and change the process so that there will be more expeditious resolution of problems which exist. Everybody admits that there are too many violations out there, technical and otherwise. The question is, how do you handle that? How do you provide incentives for people to move towards access as opposed to a standoff? And if you require a specificity such that there can be, under a reasonable person standard, notice as to what the problem is, there is a far greater chance that you're going to have a resolution of that problem. That is what this bill does simply. And I would say it has strong support from the small business community. I hope that we could reach a bipartisan accord on this. And I thank you for listening.
Well, thank you, Mr. Lundgren. And I will now begin the questioning by recognizing myself for 5 minutes. Mr. Lundgren, you've been an attorney in private practice and served as an Attorney General of California. And I'm not a lawyer, but it would seem to me that as a matter of professionalism and courtesy, a lawyer should at least make some attempt to work out a dispute prior to going to the trouble of filing a lawsuit. Does your bill require anything more than the common courtesy of asking a business to fix a violation so that a lawsuit does not need to be filed?
The only thing I would say is that it requires a level of specificity so that under a reasonable person standard, one would be put on notice as to what the violations of the AD are. And that would be my only addendum to your statement.
Well, I think your legislation is a common sense solution to predatory ADA lawsuits, and it's consistent with other civil rights laws that require notice before a lawsuit can be filed. However, those opposed to your legislation argue that if this bill becomes law, the rights of the disabled will be threatened. Do you believe that your bill will threaten the rights of disabled individuals to use public accommodations?
If my bill in any way changed the underlying proposition of the ADA, you might be able to make that argument, but it does not. What it does is change the process and provide an incentive for resolution of the problem in a specific, practical way. And it seems to me, rather than undercutting the rights of anybody, it enhances the rights of individuals who are disabled in one fashion or another. I guess I would call it a common sense approach to improve the underlying bill such that you can resolve the problem rather than extend the problem or never get satisfaction to a complaint.
Well, thank you, Mr. Lundgren, and I'm going to now yield to Mr. Nadler for 5 minutes.
Thank you. I understand and somewhat even sympathize with what you're saying in some cases, I suppose. My problem is we don't permit damages here. If someone hasn't complied for 20 years and is found not to have complied, the only remedy we have is comply. Spend the money to make your business accessible. If that is the only remedy, now in various other things we allow damages. Here we don't. But if that is the only remedy, get into compliance now in order to, an injunctive action in effect to get into compliance now. And you can't bring that, you can't bring a lawsuit even to do that until you've had a letter which presumably hasn't been reacted to adequately. What incentive is there for someone other than pure goodwill? What incentive, what legal or monetary incentive is there for a business owner to get into compliance before he gets a demand letter?
Well, thank you for the question. I would say a couple things. One is right now there are demand letters oftentimes made, but they are of a general nature. They don't put the person on notice as to how they could take care of it, so that there is not the incentive to try and take care of it with a sense of immediacy. Secondly, I would argue, having been a litigator for a number of years, that if a business called me up and said, we had this letter that told us what we needed to do, we've ignored this letter, frankly, I don't want to take it seriously, I would either tell them, find another attorney, or I would say, let me tell you what your circumstance is. You're going to go into federal court, and the first thing the judge is going to read in the file is that you were put on notice with a degree of specificity so that any reasonable person could figure out what the problem was, and you ignored it. I'm going to tell you, you're in trouble here. So I would suggest it actually gives the plaintiff an upper hand in a case where there's not been a good faith attempt to try and resolve the problem. And again, I say that as someone who's litigated.
I understand that. And certainly, if I were the attorney for a plaintiff, I might very well start with such a letter. But again, what incentive, if your bill passed, would there be for anyone to bother with compliance at all until he receives such a letter? Well, and let me ask you one other question before as you answer that. What would you think of a proposal to say, okay, we'll enact your bill, but we'll amend it to include some sort of sanction, maybe monetary sanctions, if you should have brought into compliance, if it was, say, obvious, if you didn't have to be a genius not to know that you were not in compliance and you didn't do it before the letter. In other words, some other the problem right now is that your letter, I think, would completely eliminate any incentive for someone to spend money to bring himself into compliance before that letter was received. And maybe if we had the letter, but we still had some sort of sanction for not having acted if you knew you should have acted beforehand, that would be more reasonable. What do you think of that?
Well, first of all, I would just say we're talking about my bill versus the status quo. The status quo now, one would have to ask, what is the incentive for someone to try and take care of a violation of ADA prior to legislation being filed? Ours is a predicate to the legislation, to the litigation, but it doesn't stop the litigation from going forward.
Well, excuse me, Dan. The incentive now is under the status quo is that you may be sued and be responsible not only for the expense of going into compliance, but for attorney's fees.
Sure,
that's a fairly weak incentive, perhaps, but it is an incentive.
Well, you still have that as it exists now. Mine, I think, actually puts some robustness behind the threat of a lawsuit, because you've got to take seriously if, in fact, they have given you notice. So I would say it adds to an incentive. The fact of the matter is, and I think you'll hear this in testimony, there are, for instance, 100 specific standards that deal with a disabled restroom. There are, I believe, something like 24 or 2,500 separate standards, physical standards, that deal with operating a business that comes under the aegis of this statute. To suggest that people are sitting around consciously violating these things, I think is incorrect. And the idea that they've had 20 years to do this, oftentimes we're talking about businesses that have just set up. Someone goes in, they're starting a small business. They may have, and this happens to be the case, and it goes to one of the points you made earlier about a lack of full information. They may have, and we've had instances of this, people going to the local building department of their local jurisdiction and being told, oh yeah, you've met the standards, or you know, under the law there's a grandfather clause, which there isn't. And I remember when I was Attorney General, one of the things we attempted to do was to try and help local jurisdictions in California understand precisely what the laws were. We had a case where the city of Pasadena and the Rose Bowl were undergoing a major renovation of the Rose Bowl. Part of it was a major renovation, actually a replacement of their press box. And what they intended to do with respect to accommodation for disabled was insufficient for the law. We had to go down as the office that has overall responsibility in our state and basically demand that they make the change and make it within a very short time period. They were gearing up for either the World Cup in soccer or Super Bowl, I forget which, but we did that. Now, if you're going to ask me, did they intend to violate the law? Did they? No, they didn't understand, even with their own building department, even with the information they had. So in many cases, you have these businesses that frankly are unaware. And I'm not saying they're all that way, but I'm saying the vast majority in my experience are that way. So how do we get from there to doing what we want to do, which is to get access to places of public accommodation? It seems to me creating a path where there's a greater incentive to work it out sooner rather than later is the way to do it. Now, that's my approach to my bill. You may disagree with me, but that's the intent behind it.
Thank you, Mr. Nadler. And I now recognize the distinguished gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman. I want to thank the gentleman from California for bringing the bill. And this seems like such pure common sense to me. It's a little amazing that we've sat around here for over 2 decades before something as simple as this has come forward. But I'm curious, and I maybe missed it in your testimony, how does that first notice come if you have a disabled individual who is aggrieved by this? How does that first notice come to the provider?
They would send a written notice, most likely by a letter, and to the individual owner or operator of the place of public accommodation. And in there, they would be required to have sufficient specificity such that the person receiving it under a reasonable person standard, which is common law notion, reasonable person standard would be able to determine what the violation of the act is. And then that person would be given a 60-day period of time to provide the aggrieved person with a description outlining the improvements to address the barrier, and then they would have 120 days in which to take care of it. That actually go forward.
Would this likely be the form of a letter from the attorney of the aggrieved person then?
It wouldn't have to be an attorney. It could be an individual, such so that they could describe, as I say, with particularity as to what the violation is.
So I'm just feeling that because, you know, I do some of my own work that way without going to the attorney, but if I sent a letter to someone and they ignored that letter, then it likely would be a certified letter in order to prove that they received it. I'm just trying to figure out, how do you establish how the clock starts to tick on the first 60 days?
Upon receipt of the letter, I suppose if you wanted to be careful, you could make sure it was certified, and you could also hand it to them. I mean, there's any number of ways of doing it.
Okay, but you'd have to determine that, and that's already been a legal pattern, so I understand that. And then I'm just thinking about the statement that you made about the proprietor who got back from his surgery and decided that he couldn't continue his business because the cost to recover the loss of the investment was too great. And I'm just thinking of a community in my district that they had about a lot and a half alongside a lake, and for years they had provided a dock for public access, and a tiny little town with hardly any tax base, but it was a convenience thing, and there was a little accident down alongside that and resulted in just a few stitches. And in the ensuing litigation that came, the city council just decided that's it. We're not going to allow access to this any longer because the liability is too great. And I just add that to your statement on what are we missing in this country that we don't even know we're missing because of the heavy burden of unnecessary litigation, among other things, and heavy regulation and a whole list of things. I just think the richness of the life that we have in this country could be greater if we weren't intimidating people and discouraging especially small business folks. And I started a business up in 1975, and my biggest fear then was how do I meet with all of the risk of regulation and potential litigation. My oldest son owns that company today. We're in our 37th season, but it's gotten greater and greater. And the country's changed, the culture's shifted, and we have fewer entrepreneurs per capita because of the weight of regulation, the weight of the threat of litigation. And I just would point that, I think in those days when Mr. Lundgren and I and many others in this room were growing up, we would have an idea, and someone might say, well, I've checked my moral compass now, but there's no law against it, let's go ahead. And today, it's entirely different. Now young people say, no one else is doing this, we have to get permission in order to go ahead, so let's just forget it. And I just think our society is not as rich as it might have been otherwise. I think we're losing entrepreneurs, we're losing competition in business, our costs are going up, and we have a lot of burden in this economy that's not productive, that doesn't help the quality of life. It just churns dollars and intimidates people and reduces the quality of life. And I think this bill adds to our quality of life, and anybody that can resolve this issue within 60 to 120 days is a well-intentioned person, and I don't see a downside to it at all, and I fully support it, and I'd yield to the gentleman if he had anything further like to say.
Well, I would just say there is a famous case in California dealing with a salary shop, made saddles. I think it was also a feed store. And they had actually been pioneers in working with those who suffered from disabilities in using horseback riding as a therapy. And they were sued because it was an older store, and they had a handicapped access in the side or the back, not in the front. They were sued, and yet they could never get the person suing them to tell them precisely what it was they wanted them to fix. If you question the good faith of those folks, you know, were they folks that were not interested in assisting the disabled? Well, I mean, they had been pioneers in helping with therapeutic riding, which would suggest that they wanted to assist. And so that may be an extreme example, but that is an example of the kind of thing that I think most of us would say is contrary to common sense. And what I'm trying to do here is to figure out a common sense process change that doesn't change the underlying law, but would get us to resolution sooner rather than later.
It is common sense. Thanks, Mr. Lundgren. Thanks for bringing it. I yield back.
Thank you, Mr. King. And I would now yield. Who do I yield to? To Mr. Scott from Virginia. Forgive me, sir. I thought someone else had slipped out and was
Thank you, Mr. Chairman.
huddling around the hearing room here.
Mr. Lundgren, you know, if we're going to live in a society where those with disabilities have access to public accommodations, there's going to be some inconvenience to people, but obviously, as you've suggested, it ought to be with common sense. What should the present standard is that any change in order to get into compliance that would be required has to be easily accomplishable and able to be carried out without much difficulty or expense. Is that the standard that put your constituent out of business?
That's a standard that has been interpreted by a number of different courts, and some refer to that as a small business exception. It's not proven to be a small business exception. If someone makes that claim, as I understand it, it then makes it relevant in discovery for the plaintiff to be able to see the books of the operating entity, perhaps going back any number of years to prove that relative to the amount of money they have, this would fall within that definition. And that often leads to a tremendous amount of litigation. I think we all agree that it ought to be something that's reasonably achievable, that it is not unduly costly. So I think that's a common sense portion of the law, but it does not appear, at least in the experience of those people that have come to my attention in California, to have worked in the way that we all would have thought that would have worked.
Well, if easily achievable and able to be carried out without much difficulty, expense is too stringent a standard, what kind of standard would you suggest?
I'm not suggesting to change the standard. What I am suggesting is that we have preliminary to litigation an opportunity to resolve the issue such that the priority is not put on litigation, but the priority is put on accommodation.
So you're not suggesting that we change the standard at all?
No, I'm not suggesting change the standard.
And the bill, as I read it, only applies to entry. What about everything else that's covered by the ADA?
Excuse me, I'm sorry, I can't hear you.
As I read your bill, it only speaks to a barrier to entry into a public accommodation. How about anything else that is covered by the ADA?
This is supposed to deal with the issue of removing structural barriers to entry as the ADA requires, because that is that seems to be the locus of complaints that we've received, that those kinds of claims of structural barriers without specificity as to what they are. So I mean, you and I would talk about structural barriers. It goes to those standards that have been established. As I said, I believe there are 2,500 of them in various regulations with respect to physical requirements, and they're generally known as structural barriers.
Thank you, Mr. Chairman. I yield back.
I thank the gentleman. Well, Mr. Lundgren, we're out of questions here, and I want to thank you again for testifying today. You're excused if you'd like, but otherwise you're certainly welcome to join us on the dais here, and I would like to go ahead and invite you to do that, and then also invite the members of our second panel of witnesses to come forward. I want to thank all of you for appearing before us today. Our first witness on this panel is Lee Key. Ms. Key operates and manages 2 donut shops owned by her mother in Reedley and Stockton, California. Ms. Key was born with cerebral palsy and has been in a wheelchair her entire life. Her family's 2 businesses have both been the subject of abusive ADA lawsuits, and in 2010, her family's Reedley shop, where Ms. Key regularly works alongside her employees, was sued for alleged violations of the ADA that were substantial but not exclusively based on signage not being placed in exactly the right position or the failure to have the exact number of signs called for under the applicable statute. Ms. Key was not given any notice of the alleged ADA violations before the lawsuit was filed. Our second witness is Andy Levy, a named partner with the law firm Brown, Goldstein, and Levy, where he practices on civil, criminal, and appellate litigation. He is a fellow of the American College of Trial Lawyers and is listed in Best Lawyers in America in 5 categories. Mr. Levy is a longtime member of the adjunct faculty at the University of Maryland School of Law, and his publications include the books Maryland Evidence, A Courtroom Manual, and Appellate Practice for the Maryland Lawyer. And our final witness is David Peters, CEO and General Counsel at Lawyers Against Lawsuit Abuse. Mr. Peters has been consulted in more than 900 ADA accessibility lawsuits throughout the United States and has served as lead counsel in over 300 in California alone. Through his work, he has exposed over 600 false and/or inappropriate claims in ADA accessibility lawsuits. Mr. Peters has written extensively and has appeared in numerous national television and print news features on the problem of litigation abuse. Now, each of the witnesses' written statements will be entered into the record in its entirety. So I would ask that each of you summarize his or her testimony in 5 minutes or less. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired. And before I recognize the witnesses, it is the tradition of the subcommittee that they be sworn. So please raise your right hand to be sworn. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. And I would now recognize our first witness for 5 minutes. And Ms. Key, if you'll make sure that that microphone is on before you start speaking.
Can you hear me now?
Yes, ma'am.
Hi, my name is Lee Key, and I do live in Reedley, California. I am here to express my concern regarding the Americans with Disabilities Act and how it's being used toward all businesses. I understand that all business must be accessible for all customers. I have been disabled all my life, and I am grateful for the President George Bush recognized the needs for accessible for the disabled community when he signed the ADA into the law in 1990. Public buildings should have accessible entrance doors for both wheelchairs and strollers users. Public facilities that have an eating area and restrooms should be accessible, with tables wide enough and high enough for a wheelchair to fit. The eating area should not be designated just for the disabled people. I'm going to add something right now, as this table right here does not have a sign for, say, for wheelchair only. Accessible building areas, accessible buildings allow people with disability become more independent and self-sufficient. As for me, I appreciate business that have accessible facility, but personally, I don't care if the grab bar is 40 inches or 32 inches on either side, as long as it's provided and it's there when I need it. All business owners have to recognize the needs for all customers. For example, many a business provide a carpet or rubber mat at the entrance outside or inside to prevent able-bodied customers from slipping. Many business owners are not aware of the changes or new regulations related to ADA. Not all businesses are up to code with the ADA guidelines. My mother has 2 donut shops and has been sued at both locations for alleged ADA violation. It is not fair for a business owner to receive a lawsuit package not knowing what it was for, being asked for a certain amount of money and still having to pay for the corrections. Prior to filing a lawsuit, notification should be sent to business if their facility is not complying with the ADA. All business should have 30 days to correct minor violation and 120 days for constructional barriers. In my experience, the carpet or the mat has never become entangled in my wheelchairs. If the ADA regulation remain the same and require business to remove carpets or mats for the inconvenience of the disabled people, then the ADA will be creating a hazard for the able-bodied person. We, the disabled community, should not be able to feel segregated from the rest of society. This will create bitterness between the customer and the business. I don't need a sign to inform me that I am disabled or where I should sit. The ADA should concentrate on accessible curbs and ramps that does not wrap around the building with back door access only. Generally, when I enter through the back door, I feel like business are embarrassed or ashamed to associate with me because of my physical limitations. This is understandable to a point because there are a few disabled individuals, including lawyers, that make it their personal mission in life to collect money from businesses that have never been to. It seems this handful of people feel that small businesses owe it to them because of their current situation. This makes the rest of disabled who are trying to earn an honest living look bad. Throughout my life, people in general are very helpful. Whenever I am out and about by myself, people offer their kindness to assist me. Whether I accept or decline is up to me. I also have a voice. If I need assistance, I can ask for help. I don't want business owners to cringe when they see me entering their establishment, whether or to purchase or to simply use the restroom. I would like to see the ADA regulation or federal laws to be fair and not be taken advantage of or misused. I believe our elected officials and city inspectors should inform all business in their district of all new laws and changes. If this frivolous, nitpicky, and unnecessary money-hungry ADA laws would continue, many businesses will be forced to shut down because they don't have the money to pay for the lawsuit or corrective facility. To me, it's reminiscent of mobsters requesting protection money. Thank you.
Thank you, Ms. Key. And I would now recognize Mr. Levy for 5 minutes. And you got that microphone on, sir.
Thank you. Mr. Chairman, members of the subcommittee, thank you for giving me the opportunity to testify on H.R. 3356. It would amend the ADA to require that individual defendants be sent a letter before they could be sued for violating the ADA, even if they had been violating it for years, and even if the nature of their violations were open and obvious to all, such as a few steps that could easily be ramped. It is particularly ironic that Congress is considering this bill now, when we have thousands of newly disabled veterans who need the protections promised by the ADA now more than ever. Passage of the bill will make enforcement of the ADA more cumbersome and more expensive. Worse, it will eliminate much of the existing incentive businesses have to attempt to comply with the law voluntarily. The net result of this is that there will be much less voluntary compliance. The dirty little secret of the ADA is that its enforcement provisions, particularly those relating to public accommodations, are relatively weak. Virtually alone among federal statutes, the law currently provides no damages for its violation. Since there are no damages for past violations, and if this bill becomes law, you can't be sued until you get notice, there is zero incentive to comply with the ADA until you get a letter, if you get one. And then you can comply without risking any sanction for the many years you waited to comply. Thus, the proposed amendment effectively creates a blanket nationwide exemption to the ADA. In addition, Congress correctly recognized that the federal government does not have the resources to enforce the civil rights laws entirely on its own. The ADA, like other civil rights statutes, relies primarily on private individuals for its enforcement. Lawyers who bring ADA cases already assume the risk that they will lose and be paid nothing. By making the ADA increasingly difficult and cumbersome to enforce, you create additional disincentives for lawyers to take these cases. It's basic economics. The greater the incentive, the greater the participation. The ADA is already a chronically under-enforced statute, and it benefits a group that already has difficulty accessing legal services. If Congress further reduces these incentives that do exist, the result will inevitably be less enforcement of the ADA. If you make enforcement of the ADA rely on charity, the ADA will die. One should not need a special invitation to comply with the law, particularly one that has been on the books for more than 20 years. Moreover, the notion that the epidemic of noncompliance with the ADA could easily be cured by sending a letter is, in my experience, a myth. Implicit in the idea of notification is the idea that most violators are genuinely unaware that they are violating the ADA and that upon getting a letter, they will immediately bring themselves into compliance. And yet, they can't or won't take those same steps after they're sued. That once sued, they're mired in the courts for years. In truth, this hypothetical violator, the one who would have complied if only someone had bothered to let him know there were a couple of steps preventing wheelchair access to a store, assuming he exists, can just as easily comply with the law after being sued, and under the Supreme Court's Buchanan precedent, can do so without incurring liability for any attorney's fees. Particularly disappointing is the claim that this amendment is needed to help small business. Nothing in this bill is limited to small business. Large companies who routinely employ lawyers to advise them on what other federal statutes require can certainly do the same with respect to the ADA. As for small business, the ADA already has several provisions that protect small businesses from unreasonable requirements, which Mr. Scott, in his questions earlier, pointed out. It's a flexible law. The flexibility was purposely included as a bipartisan compromise so that businesses of different sizes and circumstances could be treated differently. But with flexibility comes responsibility. One cannot fairly complain that the law's requirements are vague and imprecise on the one hand and not lift a finger to investigate what it requires on the other. In closing, I respectfully submit that passage of this ill-advised bill is unnecessary and will do far more harm than good to the cause of equality and accessibility. Thank you.
Thank you, Mr. Levy. Mr. Peters, you're now recognized for 5 minutes, sir.
Thank you, Mr. Chairman, members.
Got that microphone? Yes, sir.
Thank you, Mr. Chairman, members of the subcommittee. Thank you for the opportunity to address these issues. While I've only been consulted in about 900 ADA cases around the country, I'm in touch with attorneys who've handled a far larger number than that. So I have knowledge of a larger group of cases, and I'm here to tell you about some of the troubling practices that we've seen occurring in hundreds of cases around the country, which have not surprisingly required a number of businesses to close, and I would add that that should never need to occur in one of these cases. H.R. 3356 would change all that in that it would require an almost immediate agreement to make changes with the knowledge that if those changes weren't quickly made, the pre-litigation notice letter it requires would almost certainly be Exhibit A to a costly federal lawsuit. I think that's about the worst way to get on the wrong side of a federal judge, is to have such an exhibit in your lawsuit showing that you were asked to make a change and you weren't willing to make it. In these very difficult financial times, we need to give individuals confidence to step forward and create jobs. But hundreds of my clients have received inaccurate information from their local building departments, city leaders, and even legislators, being told that they were grandfathered and that their business didn't need to make these changes. Of course, grandfathering applies to building codes, and these laws involve civil rights at businesses that are open to the public. So while it's certainly not true that they were grandfathered, the answer is that these businesses need information, not to be blindsided by lawsuits for changes that most would gladly make if they only knew of the requirements. A lawsuit should not be the first notice they get. In 2005, I personally witnessed at least 7 small businesses close very quickly in the small mountain community of Julian, California, after an attorney demanded $200,000 as an unlawful investigation fee after he had spent a weekend there, from about 67 businesses in the name of an organization that he created and represented. The demands were calculated to increase every day during which they were not accepted. Since then, we've seen dozens of other businesses close as a direct result of these lawsuits, in many cases after making all appropriate changes, just because they never wanted to deal with the nightmare of another ADA lawsuit. But more troubling is the fact that many hundreds, if not thousands of these cases are concluded without any changes ever being made, which undermines the important public policy objectives of the ADA. Exhibit D is just one example of standard terms offered by one law firm known to have filed over 2,000 ADA accessibility lawsuits. Basically, if you pay the right price, you can obtain a settlement agreement wrapped in a strong confidentiality clause, which is, for practical purposes, all but unenforceable. Note that the agreement only requires that the defendant do what its consultant recommends, but doesn't require that the consultant be qualified or even that the items mentioned in the complaint be fixed. In many cases, hundreds of cases, they simply aren't. Many attorneys deliberately leave information about conditions which may need to be changed out of their lawsuits for fear defendants will make all of the changes and moot the case. But since so many of these cases are settled informally, many defendants never learn about all the changes they need to make. The Ninth Circuit Court of Appeals recently commented that a filer of thousands of these lawsuits admitted that he rarely mentioned all conditions which could limit accessibility for his clients in the complaints he filed because, and I quote, otherwise a defendant could remove all the barriers prior to trial and moot the entire case. We're citing Oliver v. Ralphs, which is in Exhibit E. So if one of the purposes of the ADA was that these lawsuits would operate to prompt changes for others, practices like these directly undermine that objective. But not all lawyers conceal claims. A discreet selling of noncompliance is far more common. I've been told that if my client pays the right amount, the plaintiff's attorney will agree with my access plan whether it's appropriate or not, and if that amount is not paid, they will find a way to object to it, no matter how meritorious it is. At one struggling charity thrift store, which was only months from being taken by eminent domain, I was told that if my client didn't pay $50,000, the plaintiff's attorney would contend that a power door should be installed, even though the business only had 8 months left to operate. In the same way, noncompliance is often overlooked in these cases. Conditions which are completely compliant will provide no protection. In the case of Kohler versus Flava, we had to litigate for 17 months to prove that each of the claims made by plaintiff's counsel were meritless. This required over $100,000 in legal expense for which we could not bill this very small client and for which the court declined to award us fees, as shown in your exhibits. As you probably are aware, there is a one-way fee statute in these cases by which prevailing plaintiffs almost always recover their legal fees, while prevailing defendants are unlucky to ever recover a fraction, if any of them. These have been described as the cases you can't afford to win and creates a situation where inappropriate positions can easily be taken without accountability. The Flava case was unusual because we had photographic proof that 2 of the 3 sole claims in the complaint were false. The property had previously been sued by the same attorney, and the changes had been photographed, text messaged, and emailed in 2009, so there could be no question that they did not exist in 2010 when the plaintiff claimed he'd visited. As to the third claim, the attorney had sued 105 defendants on that same claim, which is basically that a bench longer than 48 inches, a dressing room bench, would cause problems for people with disabilities. And he failed in every adjudication. But he nevertheless advanced litigation against my client on that claim for 17 months and failed in that case as well. In that case, what made it unusual was that this attorney had falsified the signatures of a deceased client of his on documents which were first prepared weeks after the client's death. When we reported this to the court, that attorney sued each of the defendants that had reported the signature forgery to the court, and so now my client had not 1 but 2 lawsuits to deal with. Another defendant had several lawsuits to deal with. Worst of all, the attorney felt that he was entitled to falsify those signatures 3 weeks after his client had died, and every judge who's considered the matter has disagreed with him. But that didn't help my small business client at all. To date, we probably have about $500,000 in fees that we can't bill the client, and we will probably not see from the court. The ADA does not need to be a game where only the attorneys win and people with disabilities too often are the losers. As you may know, vast numbers of these cases are concluded without appropriate changes ever being made. One of the reasons for this is that it can take 2 years or more to litigate a case. And during that time, attorneys must often advise their clients not to make changes for fear they will be accused of destroying evidence, as one of my clients was when making the very changes that the plaintiff sought. In that case as well, 2 of the 3 sole claims were adjudicated in the defendant's favor, and as to the third, the plaintiff failed in every known adjudication, but prolonged the litigation even beyond the summary judgment phase. Every judge we know of, moving on, in Pinnock versus Michelin, even though the plaintiff's attorney could find no problems at a site meeting with attorneys, witnesses, and experts, They nevertheless converted the lawsuit to a class action and litigated for an additional 8 months against my client. In the
Mr.
end-
Peters, I've got to ask you to wrap up here.
Understood. I wholeheartedly support H.R. 3356. It gives a plaintiff the power to have a change made immediately rather than maybe after 2 years and maybe not at all. Thank you.
Thank you, sir. Thank you very much. I will now begin by recognizing myself for 5 minutes for questions. And Ms. Key, I'll begin with you if I could. Mr. Lundgren's bill requires a plaintiff to give a business owner notice of an alleged ADA violation and the opportunity to fix that violation before a lawsuit may be filed. So I ask you the rather obvious, but I think critical question that you're uniquely credible to answer. Do you believe that it is fair to the disabled to require notice and an opportunity to fix a violation before a lawsuit can be filed?
Yes, I do. The reason is that many of us is not updated. For example, in this building, if I go around, this building is not complying with ADA. And the law is written by you guys. So how can you expect in general population to be aware what is being written if it's not being publicized? Okay? For example, I'm using a speed limit. It's posted every, half an hour, half a mile, say 45, speed limit 45. If you go over it, you get a ticket. Because you choose to go over it. Because we didn't choose not to comply. So a minor violation, 30 days is perfect. If I need a braille stickers 60 inches above from the ground, I will go to the store and get it. But if the concrete need to be removed and redo it because it's 3.8%, because it's not 2.8%, we have to find constructor. We have to find people that know how to do concrete. And that gave me 120 days to do that. It's only fair, it's for the community and for everybody. You cannot just give me a sue packet and say, you sue. What did we do? Well, because you're not complying. Well, I didn't know the law changed every 5 years or every 3 years. Was it announced? Was it publicized? Is it three strike you out? No. So we need some notice, whether from the lawyer, from the plaintiff, from somebody. Give me the list.
Well, thank you. I'm just curious, did I hear you say that this building or where you're sitting now is not ADA compliant as we've written it? Is that?
I'm sorry, say that again?
Maybe I misunderstood. Did you say that the building that we're in now or that the table that you're at is not ADA compliant as you understand it?
Yeah, your table here, I don't see a disabled symbol because, on the list that we would cite for, I believe in the ADA regs or policy is that a business owner need to put a universal word symbol on their table to signify saying, oh, this section is for you, and you only sit in here. So as you can see, I'm looking around. I don't see that in here. This is a public place.
All right.
So why it's not in your building?
Well, thank you. I hope somebody gives us notice on that.
Yeah, that would be great. May I go around and look how accessible you are?
All right. Thank you, Ms. Key. Mr. Peters, I'd like to ask you, the Access Act would require a plaintiff to send the owner or operator of a public accommodation notice of an alleged ADA violation before the plaintiff may file a lawsuit. I keep repeating the obvious, but it's important to understand really the simplicity if I'm getting it right here. The owner-operator then has up to 120 days to make necessary repairs. Given your experience with ADA lawsuits, is this 120-day time period a significant delay for plaintiffs? Do ADA lawsuits usually get resolved more quickly than 120 days under current law?
120 days.
Make sure your microphone is on, sir.
Yes, I think it is.
Right.
I did a study of 100 properties that had been sued in ADA lawsuits in federal court as far as 5 years back, so that the time for appeals or permits, et cetera, should all have been behind them. 98 of those properties still had conditions which would support a lawsuit. Only, at many of them, no changes whatsoever had been made. And at only 2 could I say, I really didn't see things that would lead to another claim. And so you ask about 120 days. That would be a dream come true for many members of my family that, and many clients and plaintiffs that I've met that tell me that they've asked for months, if not years, for changes to be made, and the changes are never made. With this bill, if you don't agree to make the change and quickly make the change, you're going to have one angry federal judge on your case, and that's the last thing any of these small businesses can afford.
Well, opponents of the bill also argue that if a plaintiff has to provide notification of an alleged ADA violation before they can file a suit, then business owners will not be have no incentive to make their buildings accessible until they receive a notice. Based on your experience, do you believe that that argument has merit?
No, not at all. There are a variety of state laws in which a business can still be sued. Action can still be brought by the attorneys general, state or federal. Frankly, the ADA is still the law. This doesn't change that. It is what needs to be done. There are massive tax credits for making ADA changes, and many businesses will obey the law because it is the law. The overwhelming majority of defendants who've contacted me simply did not understand that it was required. Sadly, they got bad information from their building departments or their city officials, but the minute they understood that it applied to them, they gladly made the changes.
Well, thank you, Mr. Peters. Thank all of you. Mr. Nadler, I recognize you for 5 minutes for questioning, sir.
Thank you, Mr. Chairman. Mr. Levy, if lawyers sometimes send demand letters before suing, what is the harm in making that a statutory requirement for everyone?
There are cases in which the lawyer representing a particular client may choose to do so for any number of reasons. The problem with making it a statutory requirement is that it creates a exemption from the law to anyone who has not gotten such a lawyer, regardless of how long the violation has occurred.
Such
so
a letter,
the clock doesn't start at all until they get the letter.
Okay, so in effect, there's no incentive to comply with the law until you get the letter.
There's no incentive at all. You're not going to have to pay damages because Title III doesn't provide for damages. So it doesn't matter how long the violation.
Let me ask you a question that I asked our colleague, Mr. Lundgren. Let's assume the statute provided that you don't have to, that you can't be sued until the receipt of the letter, but also provided for damages. Would that be reasonable?
I think that would be a good starting point, Congressman. I think that if you had a law that provided for damages, it changes the dynamic, and it no longer notification, just like administrative exhaustion in Title I, no longer provides for an exemption because damages will be running for violation if there are violations.
So what if you said that if the philosophy said you're responsible for violations, as you are now, you're supposed to comply with the law, but you can't be sued until you get a demand letter. But once you get a demand letter, or whatever you call this letter, you can be sued for violations going back.
I think that that would be...
You can get damages, rather, for violations.
That would be a much better bill than the one that's proposed.
Would it be better than the current law?
This one solves a problem that basically doesn't exist in my experience.
Would such a bill be better than the current law?
The current bill?
No.
I think
what I just suggested.
I think that the availability of damages in Title III would be much better than the existing status quo. Whether that would require, how that would be structured in terms of notification or exhaustion, clearly that's a much more even way to begin the discussion than the existing bill.
Thank you. The bill requires, Mr. Levy again, the bill requires notice that is specific enough, in quotes, unquote, for a defendant to remedy the problem. What do you take this to mean, and might this simply foster litigation over whether a letter was, quote, specific enough?
You already have look, someone goes and hires Mr. Peters and brings this letter to him. If he's a capable defense lawyer, as I know he is, the first thing he's going to do is quarrel with the specificity in the notice. He's going to say the notice is not specific enough. Here are all the things it doesn't tell us. Here are all the things we need to know. It creates issues. Issues are the mother's milk of lawyers in terms of billing time. It's going to make enforcement of this law all the more
So this is a trial lawyer's bill?
For the defense bar, it is, because they get paid whether they win or lose.
So this would, in your judgment, foster a lot more litigation. Mr. Peters,
Would have that.
what was your reaction to that? Would, in fact, a requirement of a letter specific enough lead to litigation over what's specific enough?
Well, for us to take a case, first of all, we require that the client be willing to make all required changes within 30 days, and in fact, if it can be done in 10 days, it needs to be. So,
No, but yeah.
I'm getting to your answer.
Okay.
Since Mr. Levy referred to our office, if a letter like that comes into our office, we're going to require the client to be making all the changes immediately. If the letter's not specific enough, we can get an investigator to go. I usually visit the property and meet the client and talk about the changes that.
But do you think there would be more litigation over whether it's specific enough? You'd say it wasn't, someone else would say it was.
I really don't. I must tell you, though, I have seen a small number of letters, a very small number, where someone said, I had difficulty in your parking area.
Okay.
And
But no. Mr. Levy, since I'm running out of time, well, maybe my last question. We've heard claims that businesses routinely having to shut down because of the ADA. If the required changes for existing structures under the ADA only need be made if, quote, readily achievable, unquote, why is this happening, or is this in fact happening?
It's not happening in my experience. I hear these anecdotes. They are not consistent with any universe in which I live or I practice. In fact, much more common is all you need to do is drive down the street and look at the number of storefronts with a couple of steps into them that 20 years after the ADA has been the law, no one has bothered to install a ramp. They don't need notification. What we need are stronger enforcement provisions so people will be worried enough about complying with the law that they in fact go and do so.
Thank you. My time is expired. Thank you.
Thank you, Mr. Nadler. And let's see, I guess we go to Mr. Scott here. I keep looking for Mr. Quigley here. I'm not forgetting your name, Mr. Scott.
Thank you, Mr. Chairman.
Yes, sir.
Mr. Levy, you suggested that if this bill goes into effect, there would be no incentive for any business to get into compliance with the ADA until such time as they have statutory notice of a specific violation. Is that right?
Yes, sir.
Now, what kind of voluntary compliance has occurred since 1990?
Well, everyone who has looked at this has recognized that the ADA is a notoriously under-enforced and uncomplied with law. It is, I'm from Baltimore. There is, we could take a walk 2 blocks from my office, see the number of stores that still had steps to get into them. And these are not, flights of stairs. These are a small number of steps that could easily be ramped. And it is the case that not only hasn't there been voluntary compliance up to now, there has been widespread just ignoring of the requirements of the law that are on the book. If we put further obstacles in the way of plaintiffs seeking to enforce this law, it's not complicated. There's going to be less compliance. There's going to be less accessibility. It's a simple game, as they say.
Mr. Peters, did I understand you to say that you could be in compliance with building codes and still be in violation with the ADA?
Absolutely. In fact, there are a number of direct contradictions. Speaking only for California, which is where I'm from, there are about 2,400 points between the ADA and the California Building Code. And with some you do ADA, with some you do California. It's really hard for a small business owner to know. And there are at least 7 points where they directly conflict. We get 3 experts in a room, and they can't even agree on what needs to be done at a particular business.
Well, would it make sense to work with the building code and the ADA rather than inflict this kind of bill on the public that would discourage anyone from coming into voluntary compliance?
that is what's been happening. There is an effort to reconcile the building codes with ADA standards. It's been going on for, I think, way over a decade, and the progress is commendable, but it's the uncertainty that often drives these cases.
Thank you. I have no further questions. If, Mr. Chairman, parliamentary inquiry.
Sir.
Mr. Lundgren is a member of the committee. If I yielded time to him, would he be able to ask questions?
I'm afraid, Mr. Scott, the rules don't allow the august Mr. Lundgren the opportunity to speak or to ask questions.
Chairman,
Mr.
Chairman, Mr. Chairman.
And I'm going to go ahead, given the past enforcement of that rule, we're going to go ahead and enforce that.
I would ask unanimous consent that he be permitted, if he's still here.
And with loving deference to my friend, and he understands why, I would object. However, I will take the chairman's prerogative to say that I think he has done a wonderful thing here today, and that this is a very good bill, and I hope that it succeeds. And I thank all of the witnesses for being here today. Without objection, all of the members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond as promptly as they can so that their answers may be made part of the record. Without objection, all members will have 5 legislative days within which to submit any additional materials for inclusion in the record. And with that, again, I thank the witnesses and I thank the members and observers. Thank all of you for being here, and this hearing is adjourned.